I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this series on state public record laws and the Federal Freedom of Information Act. These lessons are brought to you by NEFAC with help from the Society of Professional Journalists Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Each lesson is a continuation of previous classes, so if you haven't already, please visit nefac.org/FOI guide. You'll find there a growing library of video tutorials and other freedom of information resources. Thank you again for joining us. Now here's NEFAC's Emily Sweeney to introduce you to our instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on public records laws. This session is going to focus on the appeals process and what you can do when your FOIA request is denied. And with me is Michael Morrissey, who's an expert on this topic, and he's the co-founder and chief executive of one of my favorite websites, MuckRock. Michael, thank you so much for joining us today.
Oh, it's such a pleasure to be here, and it's one of my favorite topics. Because it's, I think, something not a lot of journalists take advantage of, but because it can be so productive. So I'm really looking forward to diving in. And thank you everybody for attending today and watching after the fact. And I hope that everybody kind of goes home and gets excited about the potential to get more information out of government and into your hands and ultimately the hands of your readers. So I briefly just titled this presentation, FOIA Appeals When the End is Just the Beginning, because a lot of times to actually get the records you need, ideally it should be you ask, they answer, you get things. One day I envision that public records and government transparency will look a lot more like Google than it looks like a bad fax machine or Kafka process. But for now, a lot of times it is persistence that pays off. It's persistence in terms of waiting for the request, and then it's persistence in pushing through those initial denials. Because transparency can be a very challenging process. We've seen every year we do sort of a series of Valentine's themed, FOIA themed Valentine's card, just because this process can break your heart time and time again, but it is something that is worth kind of pushing through. And it's something where a little bit of knowledge, a little bit of sort of going a little bit further than other people will when it comes to an initial rejection will pay off in all sorts of really exciting and amazing ways. The first part of that process is just understanding the rejection. Not all rejections are equal, as we've discovered, and understanding sort of what happened with that request. What was your actual denial from the agency? Is it actually a denial? And understanding sort of the language that agency has put in and sort of what you're up against is a really good starting point. So when you get back documents or when you don't get back documents, trying to think through sort of what is the rejection that you're pushing back on. Did they cite a specific exemption? Under the law, there are 9 specific FOIA exemptions at the federal level. We'll be talking through a number of those later. Sometimes, though, a rejection isn't actually based on an exemption, though. Maybe they just didn't get you back anything at all. Maybe they've never responded. And you're going to have a very different type of response. You're going to have a different appeal strategy based on sort of what they actually cite in that letter, if they cite anything. Sometimes these rejections don't even matter, though. And so we'll talk a little bit about sort of how to identify what is and is not worth the fight. And sometimes when you are successful at a request, it is still worth appealing, maybe because they gave you a bunch of documents and said, hey, here's a full, complete grant of your request, but you think that they still have some more stuff out there. Going back for that can be a really important strategy at that point. One thing that federal agencies have gotten a lot better at in the past few years is actually listing out sort of what your appeal rights are, which has been a great move, and also some of what the alternatives to appealing are. And so taking a look at that exemption letter, taking a look at that rejection letter or that response letter and seeing what are the options that they lay out probably will not be comprehensive, but it'll be a pretty good starting point. And then most importantly is, what are you actually trying to get out of the FOIA process? If you are on deadline and you need something shortly, and this agency says this is going to take months and months, then maybe you want to appeal that. Sometimes if the agency gives you some stuff and rejects other stuff, maybe you already got what you want. And so you don't need to appeal even then. But it is important throughout this process to kind of keep in mind, what do you as a requester want, both out of the request itself and those documents, but then also sometimes it is important that requesters take principled stands. So if you are going after some information, maybe your story is passed, but you still think it's important that that information get out to the public. I've seen a lot of journalists and other requesters continue to fight just out of principle to kind of make sure that the agencies can't kind of run out the clock on public records requests. So that's a lot to kind of take out of sometimes just an initial one-page letter and that sort of thing, but just kind of taking some time, sort of like if it was a wine tasting, kind of like that time when you're just kind of like smelling the wine and kind of figuring out how it is. That's kind of how I feel about these rejection letters. Sort of look for sort of what's the nuance there. What kind of notes are you picking up before you kind of then figure out sort of what's the next step of your strategy. But very often that next step will be filing an appeal. Nate Jones, who used to be at the National Security Archive and is now at the Washington Post, shared that 1 out of 3 appeals ends up getting more information. So 1 out of 3 times when people push back and just take this sort of free administrative step, they get back more documents. But the reality is that a very small percentage of requesters ever file any appeals. And so there's a lot of information that's out there that could be released that's probably not getting released just because people don't take the time to think through asking for more information, going back to the agency. And one of the great things about appeals is one of the things I love about Foia is you don't need to be a lawyer. You don't need to have any sort of special credential. It is a process that is open to everybody. And you don't need to kind of, put a ton of investment into kind of taking advantage of these processes beyond kind of doing a little research, thinking through, reading closely, and being willing to kind of assert your rights. And the appeals process is a really, really valuable aspect of public records and the Freedom of Information Act. The first step is, after you've kind of read through that letter, kind of take a stance, take a sense of where things stand right now. And a lot of times the first thing you're going to want to do is actually not write another letter at all, but see if sometimes getting somebody on the phone to kind of talk through the questions you have. One of the things we found is that a lot of times agencies misunderstand what requesters are going after, or requesters misunderstand what agencies are trying to convey to them. And so not every time you file a request or every time you get a rejection is the phone going to be the right answer. But a lot of times thinking through and trying to get clarification is a really good starting point. I've seen a lot of times where a requester will think that an agency is trying to stonewall them, or there's going to be sort of like this major fee that the requester doesn't want to deal with. And a lot of times those issues can be resolved by calling up the agency and say, hey, can you explain why this request is going to cost $5,000? Or can we talk about the scope of my request and why you think it's going to take 2 years to complete? And that starts a negotiation, because a lot of times requesters are kind of think of Foia as sort of a binary. You get the documents or you don't get the documents. But for agency personnel, this is usually a negotiation with the resources that they have, with the timetables that they're on. What are the things that they can get you within those parameters? And so especially if it's not an outright rejection, but it's a agency kind of saying this is going to take us 3 years, or it's going to cost a ton of money, or we looked and we couldn't find what you're actually asking for, giving the agency a phone call can be really helpful. Every federal agency now has what's called a Foia public liaison. And as the name implies, that person is kind of a little more senior position, and their job is to kind of talk with requesters, help see if they can figure out some sort of solution to the requesting challenges you have. And that means that they're there to kind of not necessarily be your advocate, but to try to talk through and see if they can come to a better resolution before you file an appeal, or certainly before you get a file a lawsuit, and they're there to kind of like help troubleshoot things. So if it's just miscommunication issue, they can be really helpful there. Now, throughout this process, ideally, you'll find a way to just resolve it. But even if you can't get the agency to kind of come and see the way you see things, it's an amazing chance to just get more information, right? And so if they say, oh, this is stored in an offsite facility, or, oh, what you're asking for, there's going to be thousands and thousands of documents for us to review, that can be discouraging, or that can feel like an excuse. But as a requester, that's more information. And anytime you can get more information about how the agency is set up, how those records are configured, that knowledge is really powerful. Let's talk about some of the specific types of rejections that you might be facing. Now, one of those types of rejections is you just don't hear anything at all, or the agency does not respond and give you the documents in a timely manner. That's called a constructive denial. At the federal level, agencies have 20 working business days to give you a response to your request. They can ask for an extension to that timeline, and a lot of times they'll get that. But generally speaking, agencies should not be dragging requests out for months, and certainly not for years. That's called, as I said, a constructive denial. And that's just basically where they haven't given you an explicit denial, but by the fact that you still don't have those records, it still counts as a denial. Now, you can appeal those types of rejections, but most agencies have a long backlog, and they'll just say, look, they can't respond to all the requests in a timely manner, and they've put it into a first in, first out queue. And so there's not a whole lot that can be done there. And constructive denial appeals generally aren't super successful, but it is one way to kind of raise some pressure on the agency in some cases, or if it's a particularly egregious delay, if there's something that's not related to the FOIA office that's delaying that request, sometimes it can be helpful. But some of the other methods, the phone calls to the agency, trying to get more information, trying to treat this as a negotiation, is usually a more successful route to go. Some of the other rejections that we see aren't actually rejections, but classifications. At the federal level, there's 3 fee categories. There's media and scientific requesters. That includes sort of academic groups and people who are using FOIA for research that as part of an institution, as well as journalists, reporters. Then there's commercial requesters, and that's sort of commercial entities using FOIA to power their business. Then there's all other requesters, and that's people who are doing genealogy research or stuff for their own interest. One of the really important things as a media requester, if you are a journalist using these documents for a story or reporting purposes, is making sure that you're classified as a journalist. That is going to be really important to make sure that the agency can't come back to you with really large fee estimates or kind of hit you with kind of unexpected costs. If you see that, usually it's something you want to notice in that initial acknowledgement letter, and then kind of say, look, you classified me as all other, you classified me as a commercial, I'm filing this request as a journalist, and I should be given media fee category status. Now, that's really important because the next type of rejection we see a lot is a fee waiver. And a lot of times people get those confused, right? So people say, oh, I'm a journalist, I should get a fee waiver. Fee waivers, legally speaking, have a pretty high bar to get. You need to kind of prove out a strong public interest. And it's a fairly complicated legal test. And a lot of times people focus on that fee waiver, but some agencies are pretty generous with fee waivers. Others very, very rarely, if ever, give them out because maybe they think it's a short request, they give you a fee waiver, and then there's millions of pages. They're now on the hook to process all that. And so a lot of times agencies will fight tooth and nail to not give a blanket fee waiver. But if you are in the media fee category status, there are very limited in the types of charges that they can assess anyway. And generally speaking, they won't be able to charge you anything. So go for the fee category. Typically speaking, I tell people don't bother appealing the fee waiver request as long as you're properly categorized as a media requester, because you're just setting yourself up for a larger fight and a longer kind of drawn out request process that at the end is probably not going to matter. Those are some of the most common types we've seen, but if you get something that's a specific rejection, if you're dealing with something else, before I kind of get into some of the specific categories, I did kind of want to talk about some general resources that we found super, super helpful, because I think a lot of times people see legal citations, or they'll see court cases, or they'll kind of see some legalese and get a little freaked out. And to be honest, I completely understand that. As I mentioned earlier, I'm not a lawyer. I just kind of learned this through lots of mistakes over the years, but there's some really fantastic resources out there to kind of help you navigate this stuff. And you do some basic searches and reading, it's actually not that hard to parse as you kind of get used to it. Foia.wiki is a resource that's collaboratively run by the Reporters Committee for the Freedom of the Press and a variety of other organizations, including MuckRock, that has detailed information on a variety of both federal exemptions as well as sort of other ways that requests can be rejected. And it goes deep on, so you can kind of go there, search through a category and get some really great information. The Department of Justice Office of Information Policy is sort of the federal lawyers' perspective on FOIA exemptions and best practices. And it's a really readable kind of resource that also goes into sort of how exemptions should and should not be applied. And then finally, the Office of Government Information Services has a lot of decisions that they've published over the years that detail sort of how exemptions are applied and sort of what are some resources that you can use. And so the great thing about those letters is that you can search for something you've run into, take it back to the agency and say, hey, look, actually, based on this earlier decision, you should have decided this earlier. And OGIS does not actually kind of like decide a verdict. It's not sort of like in a normal appeal process. So it's just a helpful resource that kind of has a lot of good citations and data. So we're going to do some lightning rounds, kind of looking at some of the most common types of federal exemptions. There's 9 federal exemptions. The first one is one of the most annoying: national security. So if you get something that's rejected under exemption 1 or exemption B1, all the exemptions start with B based on the sort of subcategory of the code that they're in. That's a really tough one to kind of push back, because it means that the government has decided that this is classified information. Now, what you can do is you can sort of file what's called a mandatory classification review, which is a process that sort of like runs parallel to FOIA, that says if something is no longer a national secret or it doesn't need to be classified anymore, they'll kind of go through and kind of re-review that information. So if you Google MDR, that's a pretty good resource. Unfortunately, B1 is usually a place that's very hard to get appealed, because that is sort of information that is properly classified. Next exemption, B2, internal practices, right? The government says that if something is just like, hey, what's our internal lunch menu or something like that, if it's something that has no bearing on the public, if it's an internal policy, that is technically exempt from FOIA. I don't usually see B2 cited a lot because it's not a super strong exemption, because there's now also a no foreseeable harm standard in a lot of ways that FOIA exemptions are applied. And so here you would just want to make an argument about, actually, you know, it does matter sort of like this policy, because it does have sort of externally facing outcomes. And so what you need to do is kind of argue that there is a public interest in this material. My least favorite exemption is B3. Because basically B3 is, we talk about there's 9 FOIA exemptions. B3 basically says if any other law beyond these FOIA exceptions says that something is not releasable under FOIA, then it's also not subject to FOIA. So it's like, why bother having those other 9? But here again, a lot of times it pays to actually go and look at what do those other laws say, because agencies a lot of times misinterpret them, or there's some kind of like detail that will give you an exemption to that exemption. So you can sort of say, oh, this information is exempted, but maybe the agency that submits that information to this agency is not exempted, so I can go to this other agency for that information. The Liberative Process. This is where agencies want to have some sort of internal leeway to kind of debate and kind of brainstorm ideas without the fear that this information will eventually be made public. And this gives them a chance to kind of spitball things and that sort of thing. Here, what you want to do is sort of look for sort of what are the arguments that they were using facts to kind of drive these decisions, because the deliberative process only applies to sort of opinions and pre-decisional information. But any decision that a government decision maker is going to be making is going to be based off data that they have. And that data, that information that they're basing those decisions on, is not actually exempt from B5. And what we found is that if you can start proving that pieces of that document are not fully exempt under B5, is that agencies eventually will kind of relent on most of the other data. And so once you've kind of found one way into that, maybe that's sort of a copy of any studies that contributed to this decision or any kind of other sort of factual materials, a lot of times you'll find that you kind of get into a whole range of other really interesting documents as well. Another one, B7, law enforcement sensitive information. So records or information compiled for law enforcement purposes that could be interfere with an investigation, that could impugn somebody's right to a fair trial, violate privacy, all these different things that agencies can claim are law enforcement sensitive. And so what you want to do here is kind of look for indications that pieces of this information have come out before, or make an argument that the release of this information is not going to jeopardize an investigation or jeopardize future investigations. One of the things here, though, is that a lot of times law enforcement at the federal level has to coordinate with law enforcement at the local level. And so one thing we found is that looking at state or local agencies that might have coordinated with that federal agency, they'll release that at the state or local level, even if the federal agency might claim that that is exempt. And so thinking about other paths towards the documents you want. Speaking of which, making sure agencies are actually citing valid exemptions. This doesn't happen as much at the federal level, but sometimes an agency will say, oh, this is copyrighted material, or they'll say something else that sounds legalish, but is not actually a FOIA exemption. And so make sure the thing that they're saying actually is a exemption to release of those documents. Part of a document being exempt does not mean that all of a document is being exempt. There's something called segregable information within the world of FOIA. And so if they say, oh, that this is pre-decisional, well, you know, the footnotes on that document or whatever else are not going to be, the page numbers are not. There's always something that's probably not exempt. And so pushing them to actually kind of go through and only redact the information that is truly exempt is important. And then a lot of times, if you kind of do this basic research, if you look at some of the resources we talked about earlier, you'll quickly be able to kind of think through ways to kind of get around these exemptions and push back against those rejections. And then just very, very briefly, I did want to kind of just note that the official administrative appeals process is not the only way to kind of get around a rejection. At the federal level, there's the Office of Government Information Services, which is kind of like a marriage counselor for requesters and agencies. They do mediations. They don't do decisions. They don't kind of like come out with sort of orders and that sort of thing. But a lot of times they can help start a conversation and kind of help people take a step back and sort of look through, okay, what can we do to actually kind of get to a better resolution for this process? There's also, as I mentioned before, MDRs, the Mandatory Declassification Review Process. And that says if something is currently classified, any member of the public can ask for that to be reviewed and see, does this need to stay classified? Not many people know about this law. It's pretty cool to be able to kind of like spur something to get reviewed and get released. Pretty exciting. There's FERPA, which is a federal law that applies to educational records. You can ask an educational institution for documents about yourself. So if you're in college, if you have a source that's in college or recently graduated, you can file a FERPA request and they can get information about themselves. Similarly, you have extended rights to information about yourself from the federal government under the Privacy Act. So if you're asking for documents about yourself, or if you're working with a source, you can have them file what's called a Privacy Act request. It usually goes to the same office as a FOIA request. And that forces the agency to kind of give them more information than they would give the general public. And then finally, think about ways to kind of go around that problem. Look at what other agencies might have access to the information that you care about, what other agencies might have ways kind of in. So if one agency is not giving you what you want, think about who else might have those documents and kind of go after that. And most importantly, always be filing both requests, but also appeals. not enough people are taking advantage of this process. There's a ton of really amazing ways to kind of like use the appeals process to get access to more information. But it won't work unless you actually take the time to kind of file that appeal and push back against that initial rejection. So we've got a few minutes. I would love to see if there's any specific questions that people have, and happy to try and workshop rejections or talk through specific questions that have come up.
Okay, so Nick wanted to ask, maybe he missed this, but can you explain challenging the search process?
Great question. So we did not, I didn't get into that. So a lot of times agencies, one of the most common rejections we see is agencies saying we couldn't find this information and that sort of thing. Now that can be tough, right? You're as a requester on the outside and you don't know sort of like how the agency is structuring things. So I think it can depend. I think there's a few different strategies here. One, if you're really curious about an agency's search process, you can file a new request for a copy of their Foia processing notes. And a lot of times that can give you really amazing insights into sort of how the agency did or did not search for your documents. You can also, a lot of times I find being able to point to evidence that these documents exist is really, really valuable. And so being able to say, look, you said there was no responsive documents. The president said that these documents existed, or like these documents are referenced in this format, or this program couldn't exist unless this data existed. Pointing to evidence that those documents exist, pointing to some sort of citation, or just making some argument that this information exists is probably the best path you have to kind of pushing back against searches that were not well done. If you don't have that, however, it's still worth filing an appeal and saying, look, I filed this request. I still believe that these documents exist. I don't believe that they did a sufficient search. And just putting whatever, if you don't have other additional information that you can give them, putting that in, and I've seen that work. I once had an agency reject a request that we saw, and then the user just responded, yes, you do have those documents, search again. And then like 2 months later, they got 90 pages of documents. And so it was a very curt appeal, didn't have additional information, but it was still effective. And so I think if you've got more, just pointing out sort of what's there, pointing out sort of like logically that those documents must exist is your best path. But if you can't do that, still appeal, still worth it.
Jean has asked for statistical information from the BOP. I'm assuming that's Bureau of Prisons, 7 months ago. And she was told her request was complex, quote unquote. I was not giving a specific timeline. Ridiculous. The information either exists or it doesn't. I have called and got nowhere. Is BOP particularly obstructionist?
BOP is particularly obstructionist. I found BOP one of the bizarrely most hard to get information out of. And then also, a lot of the jails and prisons get a very large number of requests from prisoners. And so they do tend to be more backlogged, but Bureau of Prisons, just process-wise, I haven't thought about them in a while, but they're pretty bad to deal with. I think there it is, trying to kind of figure out sort of what leverage. I think trying to escalate to a Foia public liaison, I don't have any experience there, but trying to also use things like the Office of Government Information Services to kind of open some mediation. A lot of times what you want to do is kind of be the squeaky wheel. Now, you don't want to be too aggressive or too kind of like bull in a china shop about this, but I think figuring out sort of what can you do to kind of like escalate the importance and highlight, your persistence as a requester can be important. Unfortunately, statistical information at a number of agencies can be exempted just so that they can get candid responses, and that can be a tough one. But if something's kind of like held up there, one thing I've also seen that can be helpful is filing a new request, again, for the Foia processing notes. And one thing I've seen is that a lot of times if something's stalled, it's not because of a problem within the Foia office, it's because the Foia office can't get a response from somebody else within the agency. And so by asking for these details, that kind of tends to prompt it to start moving along in some cases in a surprisingly effective way.
Thank you so much, Michael, for everything that you went over. This was really enlightening. So thank you.
It's my pleasure, and looking forward to hearing all the appeal success stories.
Excellent. All right, take care, everybody.